I have some bad news for people who've had their cases administratively closed before the immigration court. So what I have in front of me is a motion from the Department of Homeland Security to recalendar a case which was administratively closed in 2015. I'm just going to read a couple sentences from this. A lot of it is boilerplate restating the law, so it's unnecessary. But it basically says the Department of Homeland Security moves the immigration judge to recalendar this case. The immigration court ordered that this case be administratively closed in 2015. However, based on recent checks, DHS has determined that the respondent has not been accorded any new lawful permanent status based on collateral relief filed with USCIS. DHS seeks to recalendar this matter to resolve the respondent's case on the merits and prevent unreasonable delay in the resolution of respondent's removal proceedings. DHS requests the immigration court to exercise its discretionary authority in this case in the important public interest in the finality of immigration proceedings. Accordingly, DHS respectfully requests that the immigration court grant DHS's motion to place this case on its active docket. So this was a case that had an I-130 filed in 2015. So the respondent, the person in removal proceedings, had a U.S. citizen spouse who filed a case, I-130 family petition for them, and the immigration judge basically said, like, okay, we could administratively close this case. Administrative closure means that the case is still technically active. It's on the court's docket. It's not terminated. It's still technically there, but it's inactive. So I misspoke a second ago. And what they want to do now is schedule a new court date for this case. This case was closed back in 2015 before Trump's first presidency. And now they want to reopen the case to get this guy a removal order. This is in line with a lot of the stuff that the Trump administration is doing. I'm gonna be putting out some other videos this week on some of the other tactics they're using to ramp up the number of removal orders and detentions of immigrants who are in the United States without permanent resident status. If you want to stay up to date with all of that, be sure to subscribe. If you yourself had your case administratively closed, just be on the lookout. If you had an attorney, your attorney might be receiving a notice to recalendar that case. I do plan to challenge this, and we received a couple of these, by the way. This is just the most recent. And there's a couple ways you can challenge them. For example, one way is that the regulations require that the Department of Homeland Security include a bunch of additional information and documents with their motion. And with this one specifically, they did not. So on that basis, we're gonna challenge this, and it's gonna depend on which judge receives my opposition to this motion to reopen. We'll see what happens with that. Ultimately, it's going to be down to the immigration judge. Luckily, this case is in New York City, where we have, in my opinion, some of the best immigration judges in the country. If you're going through something similar or you're worried, you could always reach out to my office. Our information is in the video description below. And if you want to stay up to date on the immigration topics under the Trump administration, be sure to subscribe. I'll see you guys next time.